Hello everyone, I'm Sam Shihab with the law firm of Sam Shihab and Associates. With me is attorney Brian Burke, and today we are presenting to you a third video of a three-part series regarding what happens if there is a change of employment or termination of employment during the green card process. This specific video talks about the change or termination of employment during the adjustment of status process. Now, we broke it down to two parts, Brian. The first part is...
It's withdrawal of a pending I-140 when the I-485 is in process. And we've actually broken this down into two subparts of that. There's withdrawal of a pending I-140 while the I-485 is pending less than 180 days. And there's withdrawal of a pending I-140 when the I-485 has been pending for more than 180 days. And those are already a lot of words already, Sam. There's a lot to talk about. So we have a nice chart. So, I'm going to talk about the first half, which is on the left-hand side of the screen. It's withdrawal of a pending I-140 while the I-485 has been pending for less than 180 days. So, when an employer submits a withdrawal of a pending I-140 when the I-485 has been pending for less than 180 days, the employer's withdrawal power is absolute. When they withdraw that I-140, there's no chance of the beneficiary retaining any benefits. As a result, the I-485 will be denied, and the priority date for the I-140 petition will not be retained. And you know, if you were requesting benefits based upon that pending I-140, like an H-1B extension beyond 6 years, well, that's something that should be done before the I-140 is withdrawn, because you would lose those benefits as with the withdrawal of the I-140.
Excellent summary, Brian. Now, when the adjustment of status crosses the magic 180-day mark, things change a little bit. So if the employer requests a withdrawal of a pending I-140 while the I-485 that is pending has crossed 180 days, USCIS will look at this application and will try to approve the I-140. It is in their discretion to approve it even though the employer requested a withdrawal if the I-140 was complete on its face, meaning that all the necessary evidence is in the I-140 petition and it's approvable on its face. USCIS might go ahead and approve the I-140 to allow for the I-485 to continue to move on through portability with the change of employment, hopefully, as you move on to a new employer. If that happens, that's wonderful, and you can definitely file Supplement J if you move on to same or similar job classification and move the I-485 application, and your green card continues without interruption. However, if the I-140 that's being reviewed by USCIS, for which a withdrawal was requested, appears to be deficient, then the USCIS may issue an RFE, and if the employer does not respond to this RFE because they've lost interest in the application, they may deny the I-140, and therefore the I-485 will be denied as well, unfortunately. Now, in the event of an approval, remember that your priority date will be locked and you will be receiving certain benefits due to the I-140 approval that we have outlined in a prior video, the description of which is in the link of it is in the description below, which include H-4 EAD for the spouse. It also includes extension beyond six years, as well as the priority date being locked for you.
All right, Sam, so we have covered the pending I-140 scenarios. Now we're going to talk about the approved I-140 scenarios, and we're going to separate them into withdrawal of an approved I-140 when the I-485 has been pending for less than 180 days, and then withdrawal of an approved I-140 when the I-485 has been pending for more than 180 days. A lot to talk about here. We have another chart. All right, Sam, I'm going to start on the left-hand side of the screen. The scenario is a withdrawal of an approved I-140 while the I-485 has been pending for less than 180 days. And in this scenario, the priority date is going to be retained because once an I-140 is approved, the priority date is always retained. Now, the remaining details kind of hinge upon how long the I-140 was actually approved for. So if the I-140 was withdrawn before 180 days of I-140 approval, that's when the I-140 has been approved for less than 180 days, you're not eligible for benefits that come with an approved I-140, and the I-485 is going to be denied. If the I-140 was withdrawn after 180 days of I-140 approval, that means the I-140 was approved for more than 180 days when the employer submitted the withdrawal request, you're going to be eligible for benefits that come with an approved I-140, which again, were discussed in a prior presentation, link below. But in this scenario, the I-485 is still going to be denied.
Excellent summary, Brian. And these benefits quickly is retention of priority date, H4EAD for the spouse, and the extension beyond 6 years that comes with an approved I-140.
Yes.
Switching gears here and jumping to the right side of this table, we're going to be talking about your I-485 has been pending for more than 180 days, and your I-140 is approved. And clearly, as we've discussed before, because the I-140 is approved, your priority date is retained, which is wonderful. Now, there are two sub-scenarios here we're going to discuss, is if the I-140 was withdrawn before it crosses 180 days of its approval. So on month 2, month 3, month 4, after it was approved, there was a request to withdraw due to a change in employment or termination of employment. Now, remember, in that scenario, your I-485 has been pending for more than 180 days as well. When USCIS received that request to withdraw from the employer, USCIS will notice that your I-485 has been pending for more than 180 days and would like to give you an opportunity to move that application to a new employer. So they will issue something called a NOID, Notice of Intent to Deny, on your adjustment of status. That sounds negative, but really they're trying to give you a chance to cure a concern that came out of the I-140 request to withdraw. And they tell you that your employer is trying to withdraw your I-140 and the I-140 has been pending for less than 180 days. Do you have a new employer to substitute because your adjustment status has been pending for more than 180 days? So if you're able to reply to that NOID and through a supplement J, filing a supplement J, and inform them of this new employer that you have, then that's great news. Your I-485 survives and the green card application continues. Now, in the other scenario, when the I-140 request to withdraw occurs after the 180 day of its approvability, so in other words, the I-140 approval has been pending for more than 180 days, and the I-485 filing has been pending for more than 180 days, because they both cross that magic line, USCIS will not negatively impact your I-485, and you're able to continue with that I-485, move it to a new employment through a supplement J, and continue that green card application, Brian.
Yeah.
Interesting dynamics, a lot of details.
Yeah.
Hopefully it's helpful for our listeners. But that's it. Termination of employment during the adjustment status application.
Thanks, everybody.